Madam Speaker. Last year, I spoke on the House floor about my serious concerns regarding the Export-Import Bank's interference of energy companies and the country of Australia. In 2013, the Export-Import Bank approved a loan of $640 million in financing for U.S. equipment to develop an open-pit iron ore mine in Australia. The mine is owned by the wealthiest woman in Australia, not an appropriate use of U.S. taxpayer dollars. According to unions, public officials, and the Iron Mining Association, these subsidies threaten to displace nearly $600 million worth of U.S. iron ore exports and cause a reduction of $1.2 billion in domestic. Today, injustice towards U.S. companies in Australia has been continued regarding a Florida company, APR. APR constructed an $80 million power plant in Western Australia to help the people and businesses of Western Australia. Once the power generation facility was almost built, an Australian bank, ANZ Bank, seized the power plant, even though it had no legal title or ownership interest in the plant. It claimed an ownership interest in the plant based on an unfair law in Australia, which is unique to that country. This incredibly unfair Australian legislation allows U.S. companies and U.S. banks to lose their title or lien interests to their own assets, even though the Australian companies and banks are expressly barred from doing so by contracts they sign with U.S. companies. APR lost its $80 million power plant, lost the use of equipment and ability to generate electricity for Western Australians, and lost the revenue associated with the plant. That power plant and revenue was wrongfully taken by the bank. Australia legislates that U.S. companies that lease assets in Australia are at peril of losing their assets based on this unfair and inequitable law. This law is called the Personal Property Securities Act, and is contrary to the basic right to own and possess private property guaranteed under the U.S. Constitution and the fundamental right to due process and equal protection, also guaranteed under the U.S. Constitution. This law has the demonstrated ability, such as with APR, and the potential to seriously harm many other U.S. businesses and U.S. interests in Australia, and must be immediately addressed. Last night, I conducted a telephone town hall meeting in my district and was asked by a constituent about the status of the Trans-Pacific Partnership legislation. This matter is important and topical for us because of the pending Trans-Pacific Agreement, which the Obama administration is supporting and many in Congress are pushing for a vote on soon, such as this year. Laws like the Australian Personal Property Securities Act should make it very difficult for any member of Congress to vote for the Trans-Pacific Partnership. If Australia is going to continue to be our trading partner, there must be a level playing field for all parties involved. U.S. companies cannot be at a disadvantage when they do business in Australia or any other country. I strongly encourage our U.S. Trade Representative to address the situation so that inequity caused to APR and the potential inequities presented for other U.S. companies be corrected before a vote is called on the Trans-Pacific Partnership. Thank you, Madam Speaker, and I yield back.